I suspect we will have lots of people that may have joined us for the first time on this particular webinar, and you may not know quite so much about us and Actons. So I'll introduce you to the team in a second, but I'm Nick Elliott and I head the employment team at Actons. We're based out of Nottingham. It is raining here. And we work with a whole range of employer clients through from sort of startups, smaller SMEs, through to some household names, some of which are on the slide there. And we provide the sort of full range of employment law services that you would expect, through from employment tribunals, employment contracts and handbooks and policies and all that really fun stuff, through to TUPE transfers and absence management and basically messy employment situations where, you know, HR people in particular could do with some additional support. We do a lot on LinkedIn, me in particular. So if you do have your smartphone there and you want to use the QR code to connect with me, if we're not already connected on LinkedIn, that would be fantastic. We are putting regular updates out on LinkedIn almost daily at the minute when things are changing. So if you're not connected with us there, it would be great if you could. You can also connect with the team who are there, and you're going to hear from James and Laura today, who will be presenting with me. Do connect with Laura in particular. She's really, really keen to get as many followers on LinkedIn as possible because she dislikes it so much. So feel free to connect with us all there. And in terms of resources, we're obviously sharing a lot on the employment law reform, as some people are describing it, but the Employment Rights Act. And you know, it's clearly the hot topic at the minute, hence the number of people that are joining us this morning. If you would like any specific advice on any of the stuff that we talk about, then obviously do reach out either through LinkedIn or through our contact details, which you will find on our website. We also wanted just to flag a few things to you. One of the things I have the pleasure of doing is hosting a podcast called the HRD Talks podcast. The latest episode was with Kim Knight, and it's another good episode, and I'd love you to be able to check that out. I think the link to those episodes, well, that episode and all our previous episodes, will appear in the chat, so you can follow that. But if you want to have a listen, it's pretty much on every podcast streaming service that there is. So it would be great if you wanted to check that out. It's primarily senior HR people sharing their journey, I suppose, sharing their journey into HR and their kind of know-how and experience and their advice to the profession. So it's hopefully useful for anyone that's interested in that sort of thing, and also the kind of world of work generally at the minute. So you don't have to be in HR to necessarily have a listen. The other thing that I've been doing regularly is some LinkedIn Lives. And again, I think a link to our next one on the 24th of Feb will appear in the chat too. I do those with Claire Cathcart. So you may know Claire. She's founder of the Elevate Hub, and I'm the employment law expert for the Elevate Hub. It's a great community supporting the HR profession. So there's a link to that LinkedIn Live, and basically you can come along and ask us any questions that you would like on any topic pretty much related to HR. So we've had some good feedback on those already, and we'll keep doing those for a little while, I suspect. The other thing that I just wanted to highlight, a friend of ours is Dr. Joe Burrell, who's local to us in the East Midlands, but doing some great work for the HR profession more widely, particularly supporting their well-being and mental health. As you guys will know, it's a tough job being in HR, and she does an annual survey which basically tests the temperature, I suppose, of the HR profession and how they're doing. And the more people that anonymously provide their input into that, the better, really. So again, a link should appear to the survey for Dr. Joe there as well. It would be great if you were willing to take part in that. I know that she would really, really appreciate that. I can see a few people commenting in the chat, will we get copies of the slides afterwards? We don't provide copies of the slides, but we do send you all a recording. If you signed up to the session, you'll get a recording afterwards, so you can watch back at your leisure if you so wish. There are a number of things, as I mentioned, that we're sharing on LinkedIn. and I have produced some short form explainer videos. You can see some of the outtakes there on the slide. And I promise the actual videos themselves are more professional and more informative than those outtake shots. But the feedback again on those has been really useful. They're about a minute long. I think there's about 8 of them. So in theory, you could do a good chunk of the Employment Rights Act in about 8 minutes. A lot of the feedback's also been that people have been sharing them with the operational people in their business to give them a flavour of what's coming. And likewise, I've done some carousel explainers too on the various practical implications of the Employment Rights Act too. And I think Iveta very kindly is going to pop a link into some of those too. So do check those out if those would be helpful. Obviously, this sort of deeper dive into the Act is very helpful, but there's some short form explainers that hopefully are useful too. So today's session, we are going to look at a variety of different areas. We'll get stuck into some of the meat of this because we have limited time and there's lots to the Act, as you can imagine. We always like to set the scene a little bit when it comes to these sessions. Obviously, we had the Employment Rights Bill for quite some time. The government came in with this plan for change. I guess Sir Keir might have other things on his mind at the minute. There's lots of other change that's happened or might happen. And, you know, we're not going to get too political with it. But I think part of the issue that we see with all of this is that the government may not have had enough time or given themselves enough time to focus on lots of this stuff, given how comprehensive and how significant the changes are. They may, you know, have tried to rush it through a little bit, which is why we're seeing some delay when it comes to some of this stuff. And we'll look at the timeline in a second. James is going to take us through some of that. So what we will look at today is where we are now, a timeline for the introduction of some of this stuff, and we will pick out some of the key reforms. So as I said, there's lots and lots and lots that we're going to try and get through. What we've tried to do is highlight some of the most important stuff, I suppose, as we see it. And we will look at what's coming, when it's coming, essentially. So the timeline for that, what the key detail is. And lots of this, we're still short of detail because you'll hear us talk about sort of regulations and the fact that there are regulations to come which are still to be released. There's still consultation going on. So there's lots and lots of detail that is missing. But we do have some headline kind of views on what we're looking at. And we'll do our best to kind of give a view on the practical implications of each of those changes as we go, so that you're thinking very practically about, okay, well, what does this mean for us? Not just now I understand what the law is likely to say or does say. Okay, so hopefully that's helpful in terms of a kind of recap of the session. Just briefly before I hand over to James to take us through some of the detail of the timeline. There have been various documents released over time by the government, and you'll see a couple of them on the slide there. There's the next steps to make work pay, which is kind of the background to why these reforms were happening. Not a bad idea to have a read of that. Likewise, the implementing the Employment Rights Bill, that roadmap document is a useful way of getting an understanding of why this stuff is being changed and why it's happening. But there obviously have been changes to the timeline too, as recently as the 3rd of February, so a couple of days ago. And I think, again, we have a link to that third bullet point document, essentially, which is the kind of revised timeline, which was released just this week, just in time for us to talk about it today, which was obviously handy. We didn't plan that, but it's not, unhelpful for us. And essentially, it's a phased introduction over the next couple of years, which does give some time for planning, but some of it is more urgent than than other bits. And again, I'm going to hand over to James to talk us through some of the timeline.
Thanks, Nick. Good morning, everyone. As Nick said, the timeline here was 4 days ago, based on the guidance documents that were released. But on the 3rd, which was Tuesday, and as Nick said, there's a link, the government changed the timeline. And so I've put all the timeline, well, not all of it, most of the interesting bits on the coming slides. I'm not going to read it out in detail, just flag bits that essentially have changed. So some of the things that were said to come in at certain times have moved around a bit. And so that's what I'm going to highlight. One of the more interesting ones here on this 6th of April is the 7th of April, the last one, the Fair Work HC established. Why the 7th? The only reason I can think of is that the 6th is Easter Monday. So perhaps they don't want to open for business on a bank holiday. October, as you'll see, there's fewer things than perhaps you might have been expecting in October now. The main one being harassment, and beware on the last one, increase to time limits. That won't necessarily come in October 2026. It's not before. I think Laura's going to talk about that a bit later. And perhaps the headline of the 3rd of Feb release was the move of fire and rehire to January 2027. And you also might have spotted, and Nick's going to talk about this, I'm sure, in his bit, uncapped compensatory awards. There was a suggestion there was going to be consultation about that. They're not going to bother with consultation on that now. It's coming in, like it or not. And then finally, there's the even grayer elements, which are coming in 2027. Presumably that could be any time. But as you've seen from the previous slides, the favourites times seem to be January, April, October, because that's when the government likes to do stuff. Also, the cynical side of me says on some of these, will they just never come in? But we shall see. Consultations. When we did these slides on Wednesday, I updated this and I said that all the consultations had finished. And then within 1 hour of me writing that slide, they launched 2 new consultations just to scupper me. One of them I think is quite niche and technical, the one about Trade Union Recognition Code of Practice and e-balloting. But the first one is potentially very significant, fire and rehire. And it talks about considering changes to the way that the Act is currently drafted relating to what is a restricted variation, which is absolutely critical on fire and rehire. And I'll come to why in a minute. And I think it might be that they're considering, the government, rowing back slightly to make the fire and rehire slightly more watered down, or to put it another way, make it more restrict the number of things that it's more difficult to change than is currently the case in the existing Act. And I'll explain what I mean about that later when I talk about fire and rehire. So that's kind of the timeline headlines. I'm going to pass back to Nick now to talk about possibly the most significant change, unfair dismissal.
Thank you, James. That's really helpful. We are going to jump around a little bit, because it's more interesting to hear from different people, but also there's lots of different topics. So unfair dismissal, I agree with James, probably the one that's had the most headlines and maybe the most significant, although I think some of the others are pretty significant, although people maybe don't realize quite how significant they are, and we're going to help with that today. The first point that I wanted to get across with this is that there's still a fair amount of sort of misinformation out there about what actually this change will involve. And that's partly because the government have done a U-turn. Whether it's a U-turn, it's a fairly significant change on exactly what this is going to look like. And for a huge amount of time, even before I think the government were elected, we thought this was a proposal to introduce day one unfair dismissal rights. Okay, so from the point at which someone joined their employer, they would immediately have unfair dismissal protection. And that was what we were working on, for quite some time. People had written articles about it, had recorded podcasts about it, and the like. And then all of a sudden, it went to the House of Lords, and they decided they didn't like that idea. And they suggested that actually they should just reduce the 2-year marker, threshold for unfair dismissal protection that we have at the minute down to 6 months. And there was some back into sort of ping pong between the House of Commons and the House of Lords. And eventually, very surprisingly, I think, for most people, the government decided that they would concede, and actually they would just make this a 6-month right. So somebody that has service with their employer and has worked there for 6 months, at the point they hit 6 months, they will get unfair dismissal rights. So that's actually what's coming, despite the fact that if you put into something like ChatGPT, it will often still refer to unfair dismissal being a day one right, and that's coming. So be careful of that. And I've seen people talking about day one rights, which just isn't correct anymore. It's a 6-month right that will kick in at that point. The other thing that I think has confused people is that with those day one right proposals, which are no longer going to come into force, there was this new concept of initial period of employment, which was basically a bit like a probation period, but not really a probation period. And it was an entirely new concept where there would be a different process and a different regime for dismissing people during that initial period of employment. And they wouldn't have to do quite the same process and so on. And that all got very confusing. Nobody really understood what it was going to be about. And they've scrapped that altogether. And I think people are still understandably talking about probation periods in relation to the changes that are coming and the reduction from 2 years to 6 months. But this initial period of employment concept just doesn't exist anymore because it never existed in the first place. So it's really important just to keep that in mind, that actually there's lots of information that might be out there that isn't quite accurate, and that it's worth just being on top of the actual detail when it comes to this stuff. So there are a number of other things to keep in mind in this area. James has alluded to one of them when it comes to compensation. What I wanted to focus on to start with is when it's coming in. So it will come into force from the 1st of January 27. So again, there's lots of different dates: April, October, January. This one is the 1st of January, and anybody that has 6 months service at that point will have unfair dismissal protection. I think James has written an article or a blog about the fact that therefore Christmas 2026 might be a difficult time for some employees, because we suspect there may be some employers who will take the view, okay, well, we need to decide who should be with our organization at that point ahead of that implementation, for new starters in particular, obviously, who are working up to that 6-month service. And it might well be that December 26 you see an increase in dismissals, and that's a little prediction that that we are working towards because of this change, but we'll see. The other thing that surprised many people was this removal of the cap on unfair dismissal compensation. And at the minute, that's capped at a year's salary, or around 120k, whichever is the lowest. And that's being removed too. The government had said that they were going to, or at least it was being said that they'd said that they were going to consult on that. And as James mentioned earlier, they're not going to consult on that. That's just happening. So effectively, that cap won't apply anymore, which many people find strange on the basis that what that does is open up unfair dismissal as a sort of valuable claim to high earners. And you could have bankers, Premier League footballers, potentially, all who in the past would have thought, well, given how much I earn, the fact that it's capped at £120,000 isn't that attractive to me. I'll look at other claims. They may well decide that actually an unfair dismissal claim is actually worth it from their perspective, and they may lawyer up with expensive lawyers and barristers and KCs and pursue claims in the employment tribunal that wouldn't ordinarily have taken place. So that again probably won't help with the backlog that there is in the employment tribunal in a minute. And I suppose the puzzle around that is that it doesn't really fit with the main thrust of the government's proposals, which are generally to help lower paid vulnerable workers. So we'll see how that plays out in practice. In terms of the impact of the changes, one of the questions that we're regularly getting asked, and in fact I can see some of them in the chat already, is how does this then work with probation periods? And that we're aware that lots of employers will have probation periods, some don't. And again, I did a little poll on LinkedIn about that, and there were some people advocating strongly for not having probation periods and actually just having regular check-ins and doing recruitment better and so on. But the majority of people, I think, have a probation period that's in play, and they vary in length. The thing to remember is that there's no real legal standing to a probation period. It's just something that the employer decides that they're going to apply, and it's generally a review with that person to see whether things are working out. So how that interacts with the new 6-month unfair dismissal threshold is interesting, and that's particularly interesting when either people may generally have a 6-month probation period, or in fact a 3-month probation period with an extension that might be another 3 months, or might be a rolling month that could take them up to the 6-month mark. And I think there is some confusion about how all of this interacts together. And I guess the key from our perspective is keeping them separate as far as you can in your mind. Though they do interact together, they are separate things. So as I say, that probation period is kind of non-legal. It might be in the contract, so it might be contractual, or it might be in a policy, and it might be something that you want to follow, but it doesn't necessarily sit that well with this new threshold. And of course, because the threshold at the minute is 2 years, that probation period is usually much shorter, and then they don't crash into each other. Okay, so the key one I think to think about is that if you have a probation period that is currently 6 months, you will automatically, if you review that on the day that is where you hit the 6 months, you will automatically have employees obtaining that unfair dismissal protection at that point. So in theory, you could take the view that it's a bit late then, and you might want to have a shorter probation period in order to avoid handing people that unfair dismissal protection at the 6-month point. Or you might decide, well, actually, we're going to follow the same procedure come what may. So we will always take somebody through a proper, fair dismissal process, regardless of how long they've been working with us. And there are some employers that are taking that view. There are, however, plenty of employers who are taking a different view, which is we still want the ability to do what are often called short service dismissals, where we don't have to go through quite the same process to be ACAS code compliant, to follow our own internal dismissal procedures, and we want to be able to dismiss without the risk of an unfair dismissal claim. And essentially what that means is doing that before this 6-month marker for unfair dismissal protection. And if that's the case, and you want to do that via a probation review, then obviously that needs to be before the 6-month mark. Okay. The other complicating factor, and we're probably going to produce some sort of mini guide or infographic on this, because it is complicated. Although I've said keep it simple and separate, it can get complicated. The other complicating factor is that particularly in situations where somebody is summarily dismissed, so they're dismissed without notice, and therefore they don't receive their statutory entitlement to notice, which at this stage would be 1 week. There are provisions in the Employment Rights Act which actually extend their service by that week, okay, for the purposes of their unfair dismissal protection. And therefore, if you leave things to the last minute and you're getting close to that 6-month mark, you can see situations where actually that person's service is a week longer than we had expected. And this is the case now. That's not a change. That's not an Employment Rights Act change. That's actually the case now. But of course, it comes up much less frequently because most people are dismissing way earlier than the 2-year mark that we currently have. And what the changes that we're looking at here will do is condense that right down into this 6-month period, which makes things much more difficult, I think, for employers. I can see a number of people saying a little guide on this would be helpful, and we will produce that. So that's where the situation I've just described with that 1 week extension to service is where at least statutory notice is not provided. So that's usually gross misconduct dismissal, or where the employer is not giving notice for some reason. Again, that usually that's a gross misconduct situation. So what that actually means then practically is that performance management during that first 6 months, or first 5 months if you really want to be safe, or first 3 months if you're looking at a 3-month probation period, is incredibly important. more important than I think it is now. We're going to have to get managers out of the mindset of, well, it's fine, I've got 2 years to work out whether this person's any good, because we won't have. And obviously getting recruitment correct in the first place will also minimize the risk in this area too. And again, there's lots of, good people out there that can help with that kind of thing. And then I think the other thing that we're seeing a lot of our clients asking for is training on things like investigations, disciplinaries, grievances, all those kind of things where managers need upskilling to do this stuff well. And performance management obviously is one of those too, where actually it's incredibly important that managers manage well during this initial period, of course, as well as the rest of the time when they're managing people. But there's just an increased focus for sure on this area during this time. So we could talk about that for ages. And I can see James has been answering some of the questions in the chat, which is great. We're now going to look at fire and rehire, which I think James is going to pick up. This is one of those areas where I think people are missing the significance of it. And in theory, it's pretty significant for employers. So James, go ahead.
Thanks, Nick. Yeah, I was just adding some comments in the chat about 6 months service, and that is going to be a ripe argument as to it's as Nick was saying, it's not going to be so straightforward. Day one, end day, and that's going to be the key battleground, whether people have 6 months or not in certain cases. But fire and rehire, as Nick said, one of the more interesting developments in the Employment Rights Act. Just as a bit of background, I always think fire and rehire is one of the worst names this has ever been given, because that's not what people do, and it's not the context it's going to apply. So the context of this law is really about something that most people used to call dismissal and re-engagement, and that's where an employer, the common scenario anyway, is where an employer is seeking to agree contractual changes with employees, and in the event that they can't, one of the things that they might do at the end of that process of consultation, where they haven't been able to reach agreement, is to give notice of termination to the employee on their existing terms of employment, and to offer them new terms with the changes that they wouldn't agree to carry on from when their notice expires. And the employee is effectively left with a choice. They either walk away at the end of their notice period, or they accept the change. In both scenarios, they could claim unfair dismissal subject to them having sufficient service, which at the moment is 2 years. But as we've just covered in a bit of detail, that protection will be extended quite significantly. So this fire and rehire protection is kind of a double whammy, in that you've got new claims you can bring, and you could have brought the old claims more frequently, because more people will be caught by the 6 month service than were the 2 years. So that's the context of the fire and rehire. It's more of a dismissal and re-engagement thing. The phrase "it's being banned" is also quite sort of misleading. Nothing's really being banned, as I'll explain on the next slide. What is happening is that, sorry, 2 slides. What is actually happening is that a new automatic unfair dismissal category is being introduced in the context of quote unquote fire and rehire, and the slightly more sensibly named fire and replace. But the reason it's not an outright ban or even anything close to that is because these rules and these new automatic unfair dismissals only apply when, back to the idea of changing terms of employment, it will only apply where the changes are so-called restricted variations, which is an absolutely critical concept in this new law that I'll come to in a second. One of the reasons that Nick is rightly saying this is a big thing is because this automatic unfair dismissal is going to be very difficult for employers to defend claims against if they want to rely on the only defense available, which is the financial difficulties exception. I'll explain why in a minute. That's going to be a defense that will almost always fail, I suspect, if people even bother to run it. And again, we'll look at that in a bit of detail now. So what do I mean, a new automatic unfair dismissal right? Well, in a bit like in other contexts where it's automatically unfair, say, to dismiss someone for asserting a statutory right, the Employment Rights Act, as of what I'm saying now, January next year, will bring in this new right where an employer will be able to claim unfair dismissal and will be held to be unfairly dismissed where an employer has sought to vary that employee's contract of employment, and that variation includes a so-called restricted variation, and the employee did not agree. If the employer was trying to make lots of variations, this would still kick in, provided at least one of those variations was a restricted variation, and that employee didn't agree. So the A is the fire and rehire part, although you'll note there's actually no requirement for anyone to do any rehiring, whether this employee or anybody else. It's just to do with the termination. If the termination is because they didn't agree to a restricted variation, it's automatically unfair. And B is the fire and replace part. So that's where someone is dismissed for not agreeing a variation to enable the employer to employ either somebody else or the same person via re-engagement under a different contract, provided that they'll be carrying out the same duties or substantially the same duties as they carried out before they were dismissed. So they're the two scenarios that are caught. But the critical thing that you're probably gathering from this is it needs to be in relation to a restricted variation, because you either need to make a change that would be a restricted variation or offer a new contract that included a restricted variation. So what's a restricted variation? Well, this is the bit that's a bit woolly, especially now they've launched new consultation. The current legislation says that a restricted variation is variations to pay or pay linked to performance, pension terms, hours of work, holiday, or to try and add in variation clauses. It's worth bearing in mind that existing variation clauses that predate this legislation are okay, but if you try and change a contract to add in the ability to change the contract, that's not allowed. That would be a restricted variation. And the way the Act's been drafted, it also allows the government to add in anything else they want to make it a restricted variation. So this could be quite flexible as a piece of law. If loopholes are identified, then they could easily be closed off by subsequent regulations. The reason I thought the consultation which launched yesterday was very interesting is that it hinted at a couple of areas where things might be taken outside the scope of restrictive variation, which appear currently to be in it. The first one talked about expenses, and I didn't really know what the government meant by that, because I don't think anyone's particularly interested by expenses. Most contracts just say people can recoup their expenses, and people don't tend to want to change that. So that, I don't think they mean that. I think it could be some kind of tangential pay element, possibly. We'll have to see. But the part of the consultation that seemed a bit clearer was there was a reference to balance between employer and employee and shift patterns. And I think one scenario that I've talked about in past webinars that regular attendees will remember is where employers might be consulting to change shift patterns where employees are going to be no worse off. Sorry, employees are going to be no worse off, but the employer just wants to change the time of day when they're doing their shift. And under the current Act as it's drafted, if you had someone who worked the day shift and there was no ability to change that in the contract, and you fired them and then offered them the night shift, then that would be caught by this, and that would be an automatically unfair dismissal unless you could rely on the financial services exception, which I'll financial difficulties exception, which I'll come to, assuming that they objected to that change. And I'm wondering whether or not there might be some softening in that kind of shift pattern rearrangement scenario, and that might be taken outside the scope of restricted variation. I think that's certainly something they're going to discuss in the consultation, and whether it leads anywhere, we'll have to see, because I suppose the danger with this is that the more you water it down, the greater the argument that it's insignificant. But on the flip side, employers are rightly concerned that this is going to make it very difficult to change anything. Going back to expenses, the other thing that was slightly hinted at, and we'll have to see whether this washes out in the consultation, is whether the consultation will cover certain benefits. So giving employers the ability to change maybe certain types of benefits, presumably not pensions, because they're specifically mentioned elsewhere. And that would be curious that they put that in the legislation only to then change it. But benefits is a very broad term, so maybe certain benefits will be carved out. We'll have to see. I've mentioned a few times the financial difficulties exception. As I alluded to, I think this is going to be fairly useless in practice, but it's worth knowing what it is. So if you're faced with an automatic unfair dismissal claim because you've dismissed for making a restrictive variation, the only way you can establish that it wasn't automatically unfair is to win this defense. And that's where you can establish that the reason for the variation, restrictive variation, I should say, was to eliminate, prevent, or significantly reduce or significantly mitigate the effect of any financial difficulties which at the time of the dismissal were affecting or were likely in the immediate future to affect. So a huge word soup. The employer's ability to carry on the business as a going concern, and in all the circumstances, they couldn't reasonably have avoided it, which is a really long-winded way of saying, effectively, if you hadn't made the change, you'd have probably gone bust. What this doesn't seem to do is allow you the scope of foresight and saying, if we don't start cutting costs now in sort of 12 months to 18 months time, we're going to be going out of business. So it seems slightly curious that you have to wait until you're sort of on death's door as an organization before you can rely on this defense. But there we are. In previous webinars, I've talked about there is a slight tweak to this for public authorities, public sector. I'm not going to go over that again because I suspect that, one, it's not going to be of great practical importance for the vast majority of the people on the call. And as I said, I don't think this defense is going to be run very often because it's just not going to work, because it would be curious if employers are waiting this long to try and resolve situations. So what's the practical upshot of fire and rehire, assuming it comes in as it is currently aligned to do next year? The first most obvious one is a shifting bargaining position of the employees. Currently, employees might well agree to variations because they know that up the employer's sleeve is the trump card of dismissal and re-engagement. Employers now, they can just say no, and there's not a great deal that the employer can do about it other than automatically unfairly dismiss, or just back down, or I suppose rely on the financial services exemption. So it really does shift the bargaining power in the employee's favour compared to the current position. I think it's going to create a more cautious approach for employers when you're setting out terms of employment, particularly on engagement, whether that's reducing benefits or doing what I mentioned in the third bullet point, increasing the use of non-contractual policies, so committing to less in the contract and building in the ability to vary or remove things, or just referring employees to non-contractual policies that have things that quite plainly could be removed at any time. Increased use of variation clauses is a case, as the last bullet point says, get them in now because you won't be able to add them in as a variation post 1st of January, assuming this comes in then, but nothing ever stops you having new starters have contracts with variation clauses. So my strong suspicion is that employers are going to put in as many variation clauses as they can, and I can see that being a battleground in the employment tribunals for the years to come as to the enforceability of variation clauses, because at the moment that happens less because of the option of fire and rehire or dismissal re-engagement, as it's probably better described. And the fifth bullet point, bit of a bleak one. I think it encourages employers to make redundancies rather than try and save jobs in the short term or in the longer term. So the classic scenario might be you enter into redundancy consultation and the employees say, well, can't we try and ride out this difficult 6 months by all coming together and taking a pay cut? And the employer might say, well, that's a great idea, we could save jobs. But if half the employees agree and half the employees don't, it's not going to work, because the employer's faced with a situation where if you agree with half but not the other half, what do you do with the other half that don't agree? Do you unfairly dismiss them? Well, that's not going to be very cost effective. So you'd probably be better off just making a few redundancies and not facing any claims than saving jobs, because you'd be able to probably justify making redundancies. The test will be a lot better in terms of fairness than trying to fight the automatic unfair dismissal for making variations to contracts. So that could be an unintended consequence of the change, where it's sort of forcing employers to take the safe option, which is just to fire people and have fewer people, and to try and keep people and sort of ride out the wave of difficult economic circumstances. And now employment tribunals, I think, are going to go to Laura.
Yep, you're right, James. Good morning, everyone. I've got some really fun things to talk to you about. So we'll start with the employment tribunal stuff, which you can see on the slide here. So tribunal time limits. Most of you will know, and as James has covered earlier on in this webinar, most claims at the moment have a time limit of 3 months less a day. And the new Act will increase that. So the time limit to bring the claim will rise to 6 months. I know some of you are probably sitting there saying, well, Laura, that's already the case for some things. Yep, that is true. But for the majority of claims that we all see, fairly regularly, unfair dismissal, discrimination, etc., it's really important to note that they are going to change and that the people are going to have 6 months to put those type of claims in. James also alluded to this earlier, that we don't yet know when that's going to take effect. So it's kind of a wishy-washy no earlier than October 2026. Now, there's many reasons that they might have done that to not bind themselves to a specific date. But I think we just need to be aware that it's coming at some point. And it's not going to happen before October, but we'll obviously have to wait and see at what point that does come in. So the impact of those changes then. As you'll see, potentially some more time to resolve disputes, because if people have got longer to put their claim in, it potentially gives you, employers, whoever, more time to speak with each other, try and resolve the issues, see if there's a way that we can avoid it getting to that tribunal litigation stage. There are obviously some other impacts on that there is still the duty for people to go to ACAS before they put a claim in. As it has already been mentioned, ACAS also have delays, so it's potential that that's also going to read into this time that we've now got. So there is a chance that it gives you a bit more time, but obviously whether that actually happens and whether you do manage to get things resolved or not remains to be seen. A potentially obvious one, it might lead to more claims. So where people are so upset by what's happened, usually people will put their claim in fairly soon. And I can see a couple of different ways that this could go. So it might be that actually more people put claims in because they've got more time to think about it, more time to think through what they actually want to claim about. So we could have more focused claims. We've also got the option that actually it's just people have more time and the more claims are coming through and they're going to continue streaming through in the way they do now. So even bigger tribunal backlogs. A lot of you, or anyone that has got claims ongoing in their business at the moment, will know that when we say even bigger, we mean that it's going to be a bit of a problem. So as a team, we already have claims that are listed towards the end of 2028. So discussing things that happened probably at the beginning of 2025 or even the end of 2024. So there's a big time lag between things happening and the final hearing where those things actually get determined. We're also seeing that backlog earlier on in the system. So I will have clients with conversations with our clients about things that we're expecting to come through. So for example, we've been managing someone, we've been talking about it. We're saying, okay, well, we think there's going to be a claim for that. And then in 6 months' time, the claim actually arrives because it's been stuck in the tribunal system. So they've put their claim in. The tribunal haven't managed to sort it out because they are overstretched as well. And then it lands on our door. So retaining evidence is going to be crucial here. A lot of you will have retention policies that are probably quite linked to GDPR on how long you'll store things for. Quite often they'll say things like, we keep this particular type of document for this number of years. That's obviously fine, but I know that some of you also have systems that wipe. So examples that I've seen recently in claims that we've been handling are things like where staff use a WhatsApp group to discuss things that actually is really fundamental to the claim, but disappearing messages are turned on. So by the time that we get to discussing it, they've gone and no one's kept a record. Or CCTV, for example. Again, really important. It was used potentially in the dismissal. We want to be able to show that to the tribunal, but when I say to you guys as part of running the claim, could you send a copy of the CCTV? You say, oh, actually, no, it wipes after a few weeks or it auto records over. So having in mind that actually knowing that potentially tribunals are going to be looking at stuff 2, 3, maybe even 4 years down the line, retaining that evidence is really key. And I know some of you are going, well, we can't just retain everything indefinitely. That's not what I'm asking you to do. Sometimes we have a heads up. Sometimes we're involved in situations where we think, okay, this has the potential that it's going to be going to tribunal. We just know that that's going to happen. You can start making plans for that. You can start putting things aside. But equally, if you do have an internal policy that far exceeds GDPR policies or retention policies in general, because for your IT system, for example, you wipe everything, or you have a policy that as soon as somebody's left, their emails just essentially disappear and no one knows how to access them. You're going to need to start thinking about that, because the impact of these delays mean that the longer the time period goes, the more difficult it is for the witnesses to be able to remember what happened on those days and give good witness evidence, which obviously is crucial to helping defend a claim. But equally, it never looks good if we're trying to defend a claim and we're saying to the tribunal, actually, we've wiped everything, we can no longer access that because it's 3 years ago and we can't get to it anymore. So just having those kind of things in mind. So flexible working then, I did pre-warn you, we've got some really fun things here. So the key one on this is the changes are not coming into force until 2027. So it basically introduces a reasonableness requirement. So a lot of you will know there are 8 essentially grounds for rejecting a flexible working request. They are not changing. So those remain the same. The thing that is changing is that in addition to showing that the refusal is on one of those grounds, you will also have to show that it was reasonable to reject on one of those grounds. You'll see that we're saying there's power to introduce regulation. So there's going to be essentially a side document, a side regulation that might set out some specific steps that the employer needs to take to show that it was reasonable. So that could be a new process that says employers must do X, Y, and Z. We don't yet know what that's going to look like. So that is going to come out at some point, obviously, hopefully, before it comes in 2027. So we'll keep an eye on that. We're not quite sure why that implementation delay is as it is, but one idea on that is that actually it allows time for that consultation, and if they are going to introduce a new procedure that everybody needs to follow, it gives time for that to happen and for us all to know what we're going to be expected to do. So the impact of the change on this one, arguably very little changes. So at the moment, the grounds remain the same, and as yet there is no procedure, but we just need to be keeping an eye on that. Ahead of any more formal change on that, it might encourage people to ensure that they are being reasonable in their responses to requests. For example, properly explaining the reason for any rejection or any partial rejection, the grounds on which that's being rejected and why. So that's the crucial thing, that if you are not already in the habit of treating flexible working requests in a way that is likely to be helpful to you in the future when these things change, it would be a good idea to start that now. It would be a good idea to either take some advice or read into it and make sure that you know why you're rejecting things, and that, for example, your managers that are dealing with those type of requests know how to recognise a request, know how to deal with it, know how to raise it, know how to talk about it. Obviously, if you are already doing this really well, and I know that some of you on this call are, continue to do so well. And if you would like us to look over your policies or talk to you about how you are currently dealing with requests, then obviously that is something we can do, because, as I've just said, it's important that we get into the habit of doing it now so that when it changes, we're already in that routine. So I'm going to hand back to James for a few minutes, I think.
Thank you, Laura. Guaranteed hours contracts. A very different change of pace. Again, I'll do a quick recap of guaranteed hours and hours contracts and this concept of reasonable notice of shifts for those that aren't familiar. So the sort of headline area was that the government was trying to stop the abuse or misuse of 0 hours contracts and to rebalance the power between employers and employees, because employees on 0 hours, or workers as well as employees on 0 hours or low hours contracts, and I'll come to those in a minute, they don't have the power in the current legislation, and this is to try and rebalance it. So the kind of headline was this right to be offered guaranteed hours. And in essence, I'm going to slightly oversimplify, because this is if you've read the Act, or the bill when it came out is sort of mind-bogglingly complicated. But in essence, the duty is on an employer to offer a guaranteed hours contract to someone who has not got guaranteed hours based on the number of hours they'd worked in a reference period, so that they've got a bit of certainty on a certain number of hours. The right to reasonable notice of shifts, I think that's a much easier concept to understand. You can understand why workers would need reasonable notice of shifts. When this, the original bill was first released, or at least the original preamble as to what was going to be in the bill, it was said that it wasn't going to apply to agency workers. That then flipped, and it does and will, assuming it comes into force, apply to agency workers. You'll note I added that caveat, assuming it will come into force. I'm pretty skeptical that this will ever happen. It's now been delayed until 2027. It's one of those things that's in 2027. It's not one of those things that's listed on the government's timeline as January 2027. And the other reason I'm skeptical is there's no real progress on most of the concepts that were totally unclear when the draft legislation was presented. I'll go over that in a second. And then the overriding reason is that it's just hard. If the law was implemented based on the Act as it currently is, I would suggest that almost no employees would understand their rights. They would probably get a slightly misinterpreted view from AI. And most employers would be boggled. And I imagine breach would be widespread and it would just be total chaos. Because if a law can't be understood by either employers or employees, to me, it's not a very good law. So I'm skeptical this will ever happen, certainly not in its current form. And what am I getting at? Well, the key concepts to how this works are still completely unclear. So the reference period upon which the offer of guaranteed hours would be based isn't defined. People have been talking about 12 weeks, probably because that's the reference period for most other things in the Employment Rights Act. But that's just made up. It might have been in a consultation document, but it's not in any of the legislation. Another thing that's not in the legislation is a really critical thing, and that's the threshold number of hours, which determines what is and is not a low hours contract. I said I'd come back to a low hours contract. So this right for workers to be offered guaranteed hours applies where they've got a 0 hours contract, e.g. there's no guarantee of any hours at all, or the guarantee of hours is not high enough. It's a low hours contract. So let's say the low hours threshold was 10 hours a week. That would mean that you'd have to keep offering someone a guaranteed hours contract if they were a low hours contract or a 0 hours contract. So if they weren't getting enough hours, you have to keep offering them. But as soon as they've got to, say, 12 hours, they fall outside the scope of this, and they're just a 12 hours worker at that point, and they're just like everybody else. They fall outside this regime. So you can see why that's critical, because as soon as someone hits the magic threshold of being not a low hours worker, they're just like everybody else, which would mean that you would imagine that employers would pitch the amount of hours they offer to be just over the low hours threshold. So if it's too low, then this whole complicated web of legislation is going to be rendered arguably quite moot, because people will just avoid it that way by falling outside the scope of it by offering enough guaranteed hours. Or if it's too high, so many people will caught within this that it'll be an enormous headache for everyone and it'll be totally unworkable. So I think the reason they haven't said what the low hours is because as soon as they do, everyone will be up in arms. It just depends on which side of the fence you're on. If you're the employee, you'll say, well, that's too low. It's totally hopeless. It doesn't help us at all. If you're an employer, you'll say, well, that's way too high. We're going to have to be doing this mad legislation forever. So there we are. That's a conundrum that I thought was going to be subject to further consultation and presumably will be, although there is no live open consultation on this, at least that's published on the government website. So interesting to see where that plays out. And as I said earlier, what is reasonable notice of shift? I don't know. We can all have our own view, but that doesn't really matter. What matters is what the legislation's view is, and the legislation doesn't tell us. Agency workers, there might be a few people on this call that are interested in agency workers as distinct from just people on 0 hours contracts and or people on low hours contracts, whatever they may be. The legislation talks about equivalent rights applying to qualifying agency workers, but again, the picture is a very murky world. There's a concept of reference period hours for an agency worker. That's not defined. The conditions that reference period hours, which are referred to, they're not defined. And there's a concept of an excluded agency worker who presumably you wouldn't have to make all these offers to. That's not defined either. So you can see how it's very difficult to give a sort of coherent seminar as to how this is going to work and what impact it will have, because there's so little detail. It's very difficult, other than it was likely to be a massive headache unless the bar is set so low, in which case it's going to offer employees not very much. So I think it's going to be deeply unpopular, whichever way they go, which politically might mean it just disappears, but we shall see. And now on to a lot more interesting topics, statutory sick pay. I'll pass back to Laura.
Yes, thank you. The thrilling topic of statutory sick pay. So let's start with this slide, which obviously gives you the headline terms of what's going to change. So SSP will be payable from day one of sickness. So a removal of the 3 waiting days, which I'm sure a lot of you will have seen in practice and will have known about. The lower earnings limit is going to be removed, so that employees qualify for statutory sick pay irrespective of how much they earn. But bizarrely, that lower earnings limit, which is currently £125 a week, is still relevant, because anyone who earns less than that lower earnings limit, although now still now eligible for SSP, they won't be eligible to the statutory rate that a lot of you will know about, the weekly rate of £118 as it is this year, but they will be eligible to, we think, 80% of their pay. So it's a bit of a weird one that we're removing that limit. More people will be eligible to have statutory sick pay, but it doesn't necessarily mean that everybody will get the statutory sick pay rate that we've all known and loved maybe for the past few years. So there is going to be that whole, people will be entitled to it, and we just need to be aware of what the actual rate is for people. This is one where we do actually know where it's going to come into force, and it is fairly soon. So it's the 6th of April 2026. Impact of the change. So this is likely to result in more people taking sick leave if they're eligible to pay sooner, or in the case of people who previously weren't eligible to get any statutory sick pay because they didn't earn enough to meet that lower threshold. Potentially, that's going to encourage more people to take absence. There's been a lot of different views on this, and I'm sure a lot of you have got your own opinions, and as James is saying, it depends what side of the fence you're on. A lot of people are saying things like, well, great, because if it encourages people to stay at home and keep a bug out of the office that's going to wipe out our workforce for 2 weeks, then that's fine. Some people have also quite rightly pointed out that perhaps that is easier for people living with certain conditions, that if they can actually have a day at home for a mental health day, for example, that's going to be a good thing as well. But on the other hand, I know I've had a lot of chats with quite a few of you on this call about whether it's going to result in people taking shorter periods of absence more regularly, so a day or two here and there, and the impact that then has on productivity in the workplace and getting cover from other people, etc. So additional cost then, given more people will now be eligible for SSP and sooner than they were before, there is likely to be an additional cost to you as a business. So it's important to have that in mind now, and for discussions about budgets and how that's going to be managed and things you might want to consider. So whether there's going to be any changes to any enhanced company sick pay, for example, is that going to match the fact that there's no rating days? Is that going to be available to everybody? Those kind of conversations, essentially, they need to be happening sooner rather than later, given the timescale of this change. Checking your documents and your procedures. Do you have documents that refer to the 3 rating days? If you do, you should probably update them now to avoid any confusion from your employees, or simply to avoid getting it wrong, so that everybody in the business knows that this has changed. And that's a really important fact as well, making sure that everybody in your business that's involved in this process knows that this is changing. So if your accounts team, for example, need to update the system to make payment from day 1 rather than day 4, then they're going to need to know about this and make sure that they've got that in place ready to do it from the 6th of April. Also having a think about whether your current procedures for recording absence, etc., and absence and pay work, and do you need to implement perhaps a better way of recording these things, or a different way of managing absence. And then an indirect impact on the other things that you might want to consider. So given what we've just said about the fact that more people are likely to be taking sickness absence and that there's going to probably be an additional cost, you might want to think about how you're going to budget for that. So you'll see one example on the slide. Consider whether that has a knock-on impact on other benefits. So do you or would you spend elsewhere to create that budget to cover this? So anyone that follows Nick on LinkedIn will probably already have seen this elsewhere. So we are offering a sickness absence audit. As you'll see on the slide, it covers what we will do. So review your current approach to sickness absence. So sickness absence procedures, the capability processes, contracts and documentation, and manager practices. So I've seen a few chats from people saying we've been thinking about getting contracts updated for a whole host of reasons we've covered in this webinar. There are a number of things in contracts that you should probably be looking at updating and making sure that there's not gaps there. And if the sickness absence audit, obviously we'll look at the sickness absence part of that, and that's something that we're obviously happy to help with. So once we've had a look at that audit, this would just give you an idea of what we'll do. So we give you a report in simple terms, setting out the legal risks, the recommendations, the actionable steps, etc. So if that is something that you're interested in, I'm just going to pop a QR code on the screen there. So I know there's a lot of you on here and I can see a few faces, so it feels a little bit like I'm being papped by the paparazzi if I say hold your phone up and scan the QR code. But my recommendation would be, if this is something you're interested in and you're thinking, well, actually, this is going to be a big change for my business and we need to be having to think about whether our current policies, our current procedures, our contracts are up to date and work, have a scan of this QR code. It will take you to our webpage that talks you through what I've just said. I'm very aware we've given you a lot of information this morning, so if you get that webpage up, you can always have a look once you've had a break, you've had a cup of tea, and have a think, is that something we want to be looking at? And obviously we can do that. And if you don't manage to get onto the QR code, and it is something that you are interested in, if you drop one of us a message after this webinar, we'll of course give you the link to do that. I'm going to hand back to James and Nick to talk you through a few more things.
Laura was hedging her bets. It's me, collective consultation. So again, we're jumping around topics. I haven't taken control, have I? There we go. Hopefully you can all see the change to collective consultation slide. This is an area for those regular attendees that sort of mercifully hasn't really changed as the Act has progressed recently. So there is going to be a change to the collective consultation trigger. So from 2027, the duty to consult will be extended to apply in the second bullet point. The first one, where an employer proposes 20 or more redundancies at one establishment, is the current law. So we should all be familiar with that already. But the extension is that the government will introduce some other threshold test assessed across the employer as a whole, regardless of location. So flipping it back to the first bullet point, the key bit that isn't underlined would be at one establishment. And the sort of suggestion is that perhaps the second bullet point will be 20 or more redundancies across the organization as a whole, or it could be a bigger number, 40 across the organization as a whole. That's the bit they haven't said what the threshold test is, but it's very clear that it's going to be an organization-wide thing and not at an establishment thing, with the aim being, put bluntly, to make the collective consultation obligations apply more often. And as a sort of double whammy, as well as it applying more often, the penalty for failing to consult just got worse, or will get worse from 2027. So the protective award that can be claimed for a failure to consult under the Trade Union Labour Relations Act is currently a maximum of 90 days gross pay. That will double to 180 days gross pay. So if you consider that to be in this scenario, you have a number of employees, at least 20. If there's a failure to consult, that's 20 times 90 days, going up to at least 20 times 180 days. So you can see how that can get expensive very quickly. And the way that protective awards are worked out is based on the severity of the breach. So you get the maximum award if you do nothing, if you totally fail. And it's on a kind of sliding scale downwards the more that you do. The change to the trigger also means that the legislation had to be tweaked to make it practical so that it actually works with the mechanics of the legislation. So because the second threshold is talking about redundancies at different establishments, quite sensibly, the legislation says that employers will no longer need to consult all the appropriate representatives, which is the people that you need to do the consulting with, whether that's the trade union or elected employee representatives or a combination of the two. Because if you've got multi-site, they could be in different parts of the country, and clearly it's going to be impractical to shove everyone in a room or have a sort of Teams call where people are kind of bored because half of it doesn't relate to their site, which is totally different. So you don't have to do that, so that's good. Similarly, you won't be required to reach the same agreement with the representatives. The aim of consultation now is to reach agreement as to the way forward. If you're talking about two separate things, then if you had to reach an agreement, that could be quite difficult if it had to be the same agreement. So in Newcastle, you could agree something and you could agree something entirely different in Bristol, or you could agree in one and not the other. So again, that's just a change of practicality. And finally, similarly, the mechanics of it, you're probably familiar with when the duty is triggered, the employer is required to provide certain information in writing to the appropriate representatives, section 188 of Tolraka, however you pronounce it. And that list is ever so slightly changing to, again, reflect the fact that things might be different via establishments. So essentially you need to say where things apply at certain establishments and not at others, whereas currently the list is predicated on there only being one establishment, so that wouldn't be in the list currently. So that's worth bearing in mind when we get that far. Impact of the change. Well, the protective award being doubled is likely to reduce the likelihood of the what I've described as the P&O approach, which is just don't worry about following the law and just offer everyone equivalents of 90 days protective award and more. And the reason that's less likely is because it'll be more expensive. The duty will arise more often, presumably, unless they set the second new threshold in such a way that it never applies, it's bound to go up. Third one, more of a practical point, I think it might encourage more employers to introduce employee forums or consultative bodies. The reason being is if you're under the duty to consult more often under this Act, then if each and every time you had to hold an election in accordance with the legislation, that's going to take time. And you could save time by preempting that and electing an employee consultative body, which specifically has within its remit the authority to consult in such scenarios. And then finally, the most obvious one, increased risk of claims. Not that many advisors take on employment claims on a no-win, no-fee basis. The reason usually being that the costs outweigh the potential awards, because unfair dismissal awards, despite what a lot of claimants might think, are generally pretty low. But if you've got protective awards for large groups of people, I can see more union solicitors or just solicitors for large groups of employees taking on these claims, because the potential payoff of a big protective award for a big group could be very high. So I think there's an increased risk because there'll be a greater ability to fund claims, because there'll be a greater potential winnings at the end to pay for the costs and time of pursuing these claims. This section, harassment or harassment, take your pick, is another one I'm going to briefly cover. Picks up on a relatively recent change that you're probably all familiar with, where there is now a duty on employers to take reasonable steps to prevent sexual harassment during the course of their employment. That's going to change to taking all reasonable steps. So the only change is the word all is being added. I think we've debated on past webinars whether this actually makes any difference at all. To put that into context as to why I say that, is the concept of all reasonable steps already exists as a defense to discrimination claims that employers can run where they don't want to be vicariously liable for the discriminatory act of one of their employees. And what's interesting is the way the courts have interpreted that all reasonable steps defense. So what the courts or the employment tribunals more precisely do is they look at what steps the employer actually did take to prevent the discrimination, or in this context, the sexual harassment. And then they asked the question, were there other reasonable steps that the employer could have taken? And if the answer to that question is yes, then they haven't taken all reasonable steps. So as the claimant or the claimant solicitor, you're just pointing to what you claim to be reasonable steps that weren't taken. And if you can establish that, then the defense fails. Taking it back to this new duty, I struggle to understand how if someone can point out reasonable steps that you didn't take, yes, you've clearly not taken all reasonable steps, but have you taken reasonable steps? I mean, if there's 10 reasonable steps and you've taken 3, you've clearly not taken all reasonable steps, but have you taken reasonable steps? If you can just do 2 things out of a potential sort of 20, is that really what the current law is trying to achieve? Or is it really the same concept? We shall see, or we probably won't see, because I suspect there won't be any cases on the current law. Or they'll be very limited because we'll have flipped over to all reasonable steps anyway. But I don't think it's a big change, because it's difficult to see which employers are thinking, oh, there are reasonable steps, but we'll just do some. I mean, that doesn't make sense. You're either going to try and take all reasonable steps or you're not. And the only other new thing that's coming in is the government's going to be able to specify things that they will regard as reasonable steps. And that potentially is useful guidance for employers, and possibly tribunals might refer to that when deciding whether employers have taken all reasonable steps. Oops, I've accidentally clicked 2 slides. Third-party harassment. Now, this is a new thing. There was briefly law against third-party harassment when the Equality Act first came out way back in 2010. I'm fairly confident that I didn't face any claims at all for any of my clients under it. But the way it's been brought back, I think, makes it more likely that you will, or I say you, hopefully not anybody on this call, but employers will face claims because it's broader. Again, there's this concept of all reasonable steps that the employer needs to take to prevent third parties harassing their employees in the course of their employment. It applies in relation to all the relevant protected characteristics, which are defined in the harassment section of the Equality Act. And what the employer needs to look at is this test that I've put on the slide. So an employer will have permitted the harassment if the harassment happens in the course of employment and the employer failed to take all reasonable steps. So again, you're going to be in the situation where the claimant in the case is saying, well, you didn't do this, and that's a reasonable step. And if they can identify anything that the tribunal accepts was a reasonable step that you didn't take, and it's held that harassment occurred, then the employer will be liable for that harassment. A lot of commentators said that a lot of what reasonable steps are is common sense. I like to go back to the scenario of the hospitality trade, a pub. What steps can pubs take to stop third-party harassment? I think it's reasonable to say they should put up a sign. I don't think it's reasonable for a pub to have someone on the door with an iPad asking someone to read their equal opportunities policy, scroll to the bottom and tick to say they've read it before entry. I don't think that's realistic. So I don't think that would be a reasonable step. But you can see how there's huge scope for people to argue what is and isn't reasonable before an employment tribunal. And it's going to be very difficult to be confident that you've taken all reasonable steps, which then leads on nicely to what is the impact? Well, I think there's going to be an increase in claims because this is a whole new category where people can potentially sue. And it's something that is going to be arguable. It's going to be very difficult if you're an employer's advisor to sort of apply for strikeout on the basis that a claim's got no reasonable prospect of success, when someone's going to be saying, well, I could plausibly argue they could have done this, that, and the other. And the tribunal is going to say, yes, that's an arguable point. And it will proceed to a hearing, and they'll have to decide, based on hearing all the evidence, whether or not it was a reasonable step or not. I think the sectors most at risk are hospitality and retail, just because there's much greater interaction between their employees and the general public in the course of their employment. And linked to the second one, there's going to be a development in case law as to what reasonable steps are, perhaps guided by the government. And I would assume guides and codes will be released if they haven't already been, as to what's likely to be reasonable steps. But it just seems to me to be ripe for argument. And now back to Nick to finish off some last bits.
Thank you, James. And we're going to have to pick up the pace a little bit to be finished on our advertised time, but we're going to talk about some shorter areas, I think, anyway, so hopefully we'll be all good. Next one is menopause action plans. This is basically a requirement on employers with more than 250 employees to publish menopause action plans as part of an equality action plan. There's likely to be penalties for not doing that. And surprise, surprise, like many of the other areas of this session, we're waiting on more detail in regulations to give us more detail on what the requirements will actually look like, how often those plans will be published. In terms of implementation, the roadmap that we have suggests that it would be introduced on a voluntary basis in April 26, but be compulsory from 2027, I think April 2027 there. And again, practical impact here. This is an area that I've actually talked quite a lot about and shared quite openly about my experience and my wife's experience of menopause. And I think my hope is that it will bring menopause into focus for employers in a way that maybe it's not quite there yet, although there is increased awareness of the impact. I think the voluntary element to this in April this year is a good idea, and I think it will allow employers to demonstrate that they take menopause seriously and get ahead of the changes that are coming. And I guess the hope is that it will also have a positive impact on women who are experiencing menopause in the workplace. One of the things that I did want to do was give a shout out for Angela Wilkins Green, who I have done a webinar on this topic with previously, and I'll pop her LinkedIn profile in the chat, and we maybe even find that webinar and pop a link there too. She's exactly the kind of person that can help you with menopause action plans and getting ahead of that kind of voluntary date in April and compulsory in 27. So once I've finished talking, I'll get those links and pop those in. And pay reporting is the other one, just to quickly touch on. Similar sort of thing. Obviously, at the minute, pay reporting, gender pay gap reporting is a thing. This is, I guess, an evolution of that, in the sense that it's designed to encourage employers or require employers to show how they're going to close that gap. So show what steps they're taking to address their gender pay gap. And again, the slide looks very similar to the menopause slide in that it's voluntary from 26, compulsory in 27. So again, you can see the policy thinking behind that. Query whether it will help and whether actually there are other factors that could be focused on in terms of addressing those issues. But as with lots of this, we don't have a huge amount of detail as to what it will require. So it's a kind of watch this space on that issue too. Before I come back again, I think I'm handing to Laura just to cover some family-friendly changes.
Correct. So you'll all be pleased to know this is the last thing that I'm going to rabbit on about to you this morning. So there are a few changes to family-friendly leaves coming up. So again, things that are going to happen fairly soon on the 6th of April. Paternity leave will become a day one right. So at the moment, someone has to have worked for their employer for 26 weeks to be eligible. But now, in theory, someone could give notice of leave from the very first day of their employment. Same thing for parental leave. That will also become a day one right. At the moment, someone has to have worked for a year to be eligible for that type of leave. Potentially fairly substantial change down to day one. Some of you might be thinking, what on earth is parental leave? Because it certainly is a fairly underutilised leave. But essentially, it's in general terms an unpaid bit of leave. Statutory unpaid, that all parents can take in relation to each child up until the age of 18. You'll see the restriction on taking paternity leave after shared parental leave will be removed. I know shared parental leave is a really complicated thing to get your head around sometimes, and we read the policies and think, well, okay, how do we do that? How do we make that work? But essentially, what this does is flip it back round. Whereas before, if you took shared parental leave and you hadn't taken your paternity leave or you hadn't taken all of it, you couldn't go back and take that paternity leave. You lost that ability. Whereas this flips it round and says, actually, you can take your paternity leave after you've taken shared parental leave. And it also introduces a new type of leave, which is bereaved partners paternity leave, and this will enable bereaved fathers or partners to take up to 52 weeks of paternity leave if the mother or primary adopter dies within the first year of a child's life. So that's something that hasn't been available before. There are more changes to come. So James, very briefly at the start of this webinar, touched on bereavement leave and enhanced dismissal protections for pregnant women and new mothers on that roadmap as being something that might come in 2027. So consultations on both of these things finished at the end of January. So we're waiting to see what the actual changes are going to look like. And they've been consultations on various things. So eligibility requirements, notice of evidence requirements. One of the key things on the potential enhanced dismissals is whether there should be a new test to assess the fairness of dismissing someone that's returned from, at the moment, maternity leave, but that might also get extended to other family-friendly leaves as well. So there's potentially some further big changes coming down the line in this area, but obviously if they do go ahead and we do have more detail on those, we will obviously let you know and we'll update you. Again, impacts on these changes, fairly similar to what I was talking about in relation to other things. The more people that are eligible to take these kind of leaves, and obviously bringing it forward so that people have leaves from day one, in theory, the more people are going to take them because there's more people that can. Of course, whether that happens or not remains to be seen. And we've also got that slightly other side of looking at it, that actually the whole changes around employment law are fairly well known to the public at the moment. And if people are doing their research and are looking at what rights are available to them, we might see that naturally there is more people taking the various different types of family-friendly leave, or at least coming to you and saying, what type of leave could I potentially be entitled to in this situation? What's my pay for that? So knowing your policies and knowing where to guide people to is really important. Same as we've been saying on other things, reviewing any enhanced pay provisions is going to be important as well. So one glaring issue or fact on the paternity leave change is that although the right to take the leave has changed to a day one right, so you can physically take that leave from day one, the actual statutory pay that's associated to that hasn't been changed yet. So you still need 26 weeks service, bizarrely, to be eligible to receive statutory paternity pay. So that's one thing that you might want to have in mind. If you've got a company enhanced paternity pay that is currently linked to that length of service, you might want to have a think about whether you're going to change that so that everybody in your workforce gets the enhanced pay, regardless of whether they've joined you in week one or they're in the 26th week, whatever that may be. So it's something to have a look at. As I said, parental leave is unpaid. Again, have a think about whether you have any enhanced pay provisions for that, and if you don't, whether that's something you want to offer or something you want to look at and change. Particularly, again, if that was linked to the year's service that has now essentially moved. And the introduction of the bereaved partner's paternity leave, again, it's introduced that new right for people to take it. What it hasn't done is introduce any pay provisions for that. So I suspect that that is something we're going to see change in the regulations and the secondary legislation that we've all been talking about this morning, because it seems inconceivable that they're going to introduce a right such as that and then not link it to anything. But again, we're going to have to wait and see on whether that happens. As we said, keeping up to date on your policies and your contract to make sure that it is in line with the current legal positions is important. It avoids you falling into that trap that either somebody doesn't get the leave they're entitled to and they have to fight through it through their managers or HR because it's not known in the business that this has changed or things have changed. And it also avoids that slightly embarrassing moment where people have been researching their rights and they then look at your HR policy on the staff intranet and say, well, actually, your paternity leave says that I need service and I don't, so that's wrong. So updating things so that you are ahead of the game on that is a good thing. We know that family-friendly leave does get quite complicated, and the pay that's associated to it gets quite complicated quite quickly. So obviously we're happy to talk you through updating policies and looking at what those things are. And then again, just keeping an eye on the changes that might come in. There are a lot of things that have changed in family-friendly leave in the last couple of years, and I still to date, see people that haven't caught up with those changes. So actually making sure you're up to date as is now, and then looking forward, future thinking as well is really important. I'm going to hand you back to Nick, I believe.
Yep, thanks, Laura. Union changes. Unfortunately, we have nowhere near enough time to get into all of the detail relating to this. What a shame. But no doubt it will be something that we will talk about in future. And therefore, it's very much a sort of headline, this is what is coming type section on unions. So February, there's already some changes there, and you can read that from the slide. October 26, there are a variety of changes scheduled, which basically are strengthening the positions of unions, and that's, it's very openly the case that that's what it's all about. So things like having to inform your employees that they have the right to join a union, new rights of access for unions to workplaces, extra protections for people, and so on. That's the gist of those. I think the practical impact around this will likely be larger number of people joining unions, but there's a huge amount of debate on that. It's designed to make it easier for unions to operate. And I think if you don't have a union in your workplace, you may think, well, it doesn't apply to us in quite the same way. My guess is that unions will be targeting certain employers because they think, this is a good place for us to grow our membership. And it might be that you want to try and get ahead of that possibility if you're concerned about having to engage with the union in your workplace, by looking at other kind of employee voice or representation feedback bodies, which might be helpful in terms of warding off the need for a union to actually be more formally recognised. So what should we do now? We're coming into land. We've got a minute or two left. Well, hopefully you've picked up lots of practical points as we've gone along. We tried to keep it as practical as we can based on the limited detail that we still have. But I guess planning immediately for the April changes is obviously top of the list in terms of how you approach this. Looking at things like probation periods, performance management, I think are going to be particularly important. Although there's been delay to the fire and rehire changes, and James, is still skeptical as to whether they'll actually come into force or not, it might be that you want to look at the terms and conditions that you have in place for your employees at the minute, and whether you want to change any or planning to change any, because it might be more difficult to do so in the future. Keep an eye on the equality action plans and menopause reporting if you're a bigger employer, and maybe get ahead of it if you're a smaller employer. And I would also encourage you to be speaking to your finance colleagues and looking at the cost of some of these changes as well. One thing that we just wanted to plug at the very end was that training managers and keeping up to date on this stuff will be particularly important. As we said, I'm in particular sharing very, very regular updates on LinkedIn. So if you're not a big LinkedIn user, it probably might be a time to consider that, on the basis that this moves so quickly. So I'd love to connect with you on there, and we can keep you up to date as quickly as we can. Webinars and newsletters don't actually even really move fast enough for some of this stuff. I should say, sign up for our newsletter if you or any of your colleagues haven't already. We are getting lots of requests for training at the minute, and there's been some very kind comments in the chat about how people have found that really useful. If you would like that for your teams, we cover a whole range of different options, and then do use the QR code again there to have a look at what we have on offer. We'd be really happy to spend some time with you guys. We can tailor that training to the specific business that you're working in, and the team of people that would benefit from that training. And yeah, we'd love to help upskill those managers as they enter a brave new world of changes to employment law. So I can see lots of people saying thank you for the session. That's really great. We've picked up a lot of questions as we've gone. We haven't run too far over time. So hopefully, if you had a question, we have answered as we've gone along. And if you, as Laura said, if you have any queries at all in any of the stuff, then do get in touch. If you need any support with the training, or looking at your contracts and policies, or just planning strategically for this, then we'd be really happy to help if we can. there we go. Thank you so much for all the kind feedback. And we will see you again next time. No doubt we will be doing more of these as time goes on, and we get more detail, the consultations are done and that kind of thing. So we will see you then. Thanks, everybody.